The pretrial chamber will proceed to the second case file, criminal case file. I would like the reporting judge to read the report of examination, say the president. The pretrial chamber criminal case file number 002-1909-2007 ECCC PTC 15. Report of examination. 1. Proceedings. 2. Examination of the case by the co-rapporteurs. 1. Proceedings. A. Introduction. I think I may have to skip this paragraph because it repeats the previous report of examination. I would like to move to the charges. Kieu Samphan is under investigation for crimes against humanity, murder, extermination, imprisonment, persecution and other inhumane acts and grave breaches of the Geneva Conventions of the 12th of August 1949, willful killing, willfully causing great suffering or serious injury to body or health, willful deprivation of rights to a fair trial of a prisoner of war or civilian, unlawful deportation or transfer or unlawful confinement of a civilian, being crime or crimes set out and punishable under Articles 5, 6, 29 new and 39 new of the law on the establishment of the extraordinary chambers in the courts of Cambodia, dated 27th October 2004. Purpose of this report. This report of the co-rapporteur set out the details of the decision appealed against and the facts at issue before this court. It is to assist those who are not parties to the proceedings understand the matters before the court. B. Co-investigating judge's order on extension of provisional detention. On the 18th of November 2008, the co-investigating judges of the ECCC issued an order extending provisional detention of the charged person who has been detained since 19th November 2007 for another term not exceeding 1 year. The co-investigating judges dismissed the co-lawyers' arguments that Kieu Samphan's international co-lawyers' inability to examine the investigation file in a language he understands has rendered the detention arbitrary and that they must have state their decision on extension of provisional detention pending the pre-trial chamber's decision on their appeal relating to the translation rights and obligations. The co-investigating judges held that the order extending the provisional detention of Kieu Samphan is not contingent upon the outcome of the appeal against the order on translation rights and obligations of the parties. They considered that they must instead look to the requirements laid out in Internal Rule 63 to determine whether an extension of provisional detention is warranted. The co-investigating judges found that the co-lawyers' contention that they lack impartiality equate to an application for disqualification per internal rule 34(5), for which they have no jurisdiction. The co-investigating judges also concluded that they were not obliged to recuse themselves under Internal Rule 34(1), as neither the fact that they are charged with ordering provisional detention while at the same time conducting the judicial investigation, nor their previous order on translation affect their impartiality with regard to provisional detention. Further, the co-investigating judges held that there had been no change in circumstances since they issued their order refusing request for release on the 28th of October 2008, in which they found that provisional detention was still justified and necessary. C. Kieu Samphan's appeal. On the 4th of December 2008, the co-lawyers filed their appeal brief against the order on extension of provisional detention, in which they request that the pretrial chamber 1. Note that Kieu Samphan is being held on a basis of a null and void measure. 2. Order his immediate release, and 3. Avert him compensation for being detained arbitrarily and without legal authority. They do so on the ground that the co-investigating judges had to defer their decision, that they issued an unnecessary decision extending an arbitrary detention, and that the charged person is being held without legal authority. D. Co-prosecutor's response. On the 9th of January 2009, the co-prosecutors filed their response to the appeal, requesting the pretrial chamber to dismiss the appeal on the main grounds that the co-investigating judges had no obligation to defer their decision, and that the charged person has failed to demonstrate any material change in circumstances since he was originally detained. E. Civil parties' response. The co-lawyers for the civil parties did not file any responses. 2. Examination by the co-rapporteurs. A. Obligation of the co-investigating judges to defer their decision. The co-lawyers submit that the co-investigating judges were under an obligation to defer the decision relating to the extension of provisional detention for 2 reasons. First, they argue that the proceedings were fundamentally flawed and delayed primarily as a result of the co-investigating judge's refusal to order translation of all the materials in the Kieu Samphan case file, which severely impair Kieu Samphan's rights. The co-lawyers point out that they have appealed the co-investigating judge's refusal to order the translation of the case file before the pre-trial chamber, and that proceedings concerning extension of detention should have been stayed pending the outcome of this appeal. Moreover, in their view, the delay in those proceedings should have obliged the co-investigating judges to defer their decision with regard to extension of detention. Second, the co-lawyers argue that the co-investigating judges could not decide impartially in view of their position on the translation issue and the exceptional circumstances surrounding the proceedings. Further, they contend that the co-investigating judges lack impartiality owing to the fact that they are charged with conducting the judicial investigation, thereby making them unable to take into account the defense views on the issue of well-founded reasons that the charged person may have committed the crimes mentioned in the introductory submission. In response, the co-prosecutors submit that the co-investigating judges had no obligation to defer their decision. On the contrary, they had to make a decision on the extension of provisional detention before its expiry. In addition, they argue that this is not the proper forum to hear contentions regarding the impartiality of the co-investigating judges, which are in any event baseless. B. Arbitrariness of the order. The co-lawyers raised the argument that the order made by the co-investigating judges extending Kieu Samphan's detention is arbitrary because the co-investigating judges were under no obligation to decide on the extension of detention, as in principle provisional detention is for a one-year term only. The co-lawyers also submit that the order dated 28 October 2008 does not demonstrate the need for detention, and that expiry of provisional detention in itself constitutes a change which should be considered by the co-investigating judges. And further, they state that the co-lawyers for the defense clearly demonstrated that in releasing Kieu Samphan, there was no risk of pressure being exerted on any witnesses or victims, or prejudice to the public order, or, for that matter, putting his personal security at risk. Therefore, the co-investigating judges could have deemed an alternative to detention to be an appropriate measure. They declined to do so and have no reason for their refusal. In response, the co-prosecutors argue that the co-investigating judges, who are mandated by virtue of the rules to decide on the placement in as well as the maintenance and extension of provisional detention, had the positive obligation to reassess the conditions for continued detention and decide whether to extend the provisional detention order or not. The co-prosecutors assert that the defense do not challenge the existence of a well-founded reason to believe that charged person may have committed the crime specified in the introductory submission, nor identify any material change of circumstance to show that the conditions necessitating his detention under Rule 63(3)(b) are no longer met. C. Legal authority underpinning provisional detention. The co-lawyers for the charged person consider that the initial order or provisional detention issued by the co-investigating judges is null and void, as the lack of translation of the case file had led to a nullity of the proceedings. As a result, they submit that the subsequent order on extension of provisional detention should be considered to be non-existent, in that there is no legal authority underpinning Kieu Samphan's detention. Further, the co-lawyers add that the pre-trial chamber's delay in issuing a decision concerning detention obliged the co-investigating judges to release the charged person from detention per Article 278 of the Cambodian Code of Criminal Procedure. The co-prosecutors respond that this argument is without merit for two reasons. One, the defense voluntarily withdrew their appeal against the provisional detention order and thus failed to submit any alleged violation of the charged person's rights to the pre-trial chamber. 2. Article 278 of Cambodian Code of Criminal Procedure, which is the linchpin of the defense argument, is inapplicable before the ECCC. Phnom Penh, 26 February 2009. Co-rapporteurs, Judge Hoodwati, Judge Rowan Downing. The President, Mr. Kieu Samphan, please stand up. In this second case, you are entitled the same rights as I mentioned earlier, according to Rule 21(1)(d) of the internal rules. So the rights are still maintained. And in this case, this appeal, would you like to talk or to make any statement related to this appeal, or if you would like your lawyers to speak on your behalf? Mr. Kieu Samphan, I would like to give the right to my defense counsel to speak on my behalf. Thank you.
Mr. President, Your Honors, as I informed Your Honor, I would like to combine the two appeals together. So I will not repeat what I said on the detention. Regarding his initial detention, there was a controversial issue on the translation issues into the French language because the international co-defense lawyers is French, and he requested for the French translation. Therefore, I would like to make an observation only on the issue of on the deferring of the decision on the appeal against the initial detention. Because when a person is detained for 1 year, there should be a possibility for the person to make an appeal. An appeal was made and the decision on that appeal is deferred because on the 4th of December 2008, the pre-trial chamber made a public hearing but did not announce the decision. I, as the defense counsel for the charged person, think deferring such decision is a violation on his right. At least the decision on that appeal shall be reached first. So that the co-investigating judges can consider their decision on the extension of the provisional detention. However, as I understand, since Mr. Kieu Samphan's arrest on the 17th of November 2007 until the 19th of November 2008, when there is no decision on the extension of the provisional detention, he shall be released on bail. Therefore, the co-investigating judges continued the detention of Mr. Kieu Samphan on the 18th of November 2008. And we, the defense counsel for Mr. Kieu Samphan, made an appeal to the pre-trial chamber regarding that extension of provisional detention without waiting for the decision of the pre-trial chamber. This is the point that I would like to make. And this is contradictory to the principle of law. So it means they have a presumption that my client is guilty. And this is a violation of his right and freedom. I do not want to return to the issues on the grounds for his detention. I would like, Your Honor, the pre-trial chamber to consider on this issue, and I would like to remind Your Honors that we, the defense counsel for Mr. Kieu Samphan, as well as other lawyers for the charged persons, we are not consulted for the internal rules or its amendments. Usually in the past, in practice, when a client is not satisfied with the lawyers, they could appeal, or they could lodge an appeal to the appeals court. But within this particular court, such appeal is not possible for either Mr. Kieu Samphan or other charged persons. Let me now return to the issue of the translation. When there is an issue on the translation, the co-investigating judges issue an order regarding the rights and obligations on the translation issue. So they are themselves the law and they are also the judge. I would like to remind Your Honors that I have to defend Mr. Kieu Samphan. He is being detained by this court. What I remind Your Honor is on the quality of arms. And I would like all the chambers, all these extraordinary chambers in the courts of Cambodia to seek justice. I myself, I love justice. So certain points I'm not satisfied, but I have to accept it. I thank you very much, Your Honors and the President. The President, the international co-defense lawyers may make your response.
M. Samphan a dit ce que je pensais.
Mr. Kieu Samphan has said what I thought, says Mr. Verges.
The President. May the co-prosecutors make your oral submission. Thank you, Mr. President, Your Honors. In the name of the ECCC prosecution, I submit to uphold the response of the co-prosecutors against the appeal by the defense lawyers of Kieu Samphan, and I would like to make additional observations as follows. On the 18th of July 2007, the co-prosecutors submitted the introductory submission and also on the extension of the detention not exceeding 1 year. And on the 4th of December 2008, the defense lawyers lodged an appeal to the pre-trial chamber, and the pre-trial chamber set a date for the 27th of February 2009 regarding that appeal. However, the hearing was adjourned due to the absence of the international co-defense lawyer. The defense lawyers submit that the charged person shall be released because the co-investigating judges have an obligation to defer their decision. The co-investigating judges are not partial, thus cannot render an extension order for provisional detention. The co-investigating judges issued an unnecessary decision on an extension of provisional detention with inappropriate reasons, and the extension order for the provisional detention was based on a non-existent measure. In this matter, the prosecution submits that the co-investigating judges have no obligation to defer their decision, but they have an obligation to decide on the issue of extending provisional detention. There is no provision or article in the internal rules of the Code of Criminal Procedure authorizing the co-investigating judges to defer their decision-making or waiting until such time the pre-trial chamber makes its decision in a separate procedure. An appeal to the pre-trial chamber does not have an effect to interrupt any proceedings. Rules 63, 4 and 7 do not specify any effect for suspending a charged person's appeal against a co-investigating judge's order. The co-investigating judges do not have an obligation to defer any proceedings. It is insufficient to base on an irregular process of the proceedings before the pre-trial chamber to prevent the co-investigating judges from taking measures necessary for their investigating process, and specifically their decision to extend provisional detention. A violation of the charged person's right as submitted in respect of the translation issue for documentary evidence, and which has been mentioned in every submission made by the defense lawyers since April 2008, is vague, unclear, and mostly based on an assumption. Arguments raised by the defense lawyers in their submissions intend to define a delay in taking measures as being equal to procedural infringement. Moreover, as a consequence, delaying in making extension decisions of provisional detention can impact the investigation, as it can lead to a release of the charged person, although the co-investigating judges have found that the release will lead to eventual risks on victims and witnesses, on preserving evidence, on the security of the charged person and public order, and these actions can lead to violation of Rule 63.3a and b. The defense lawyers for the charged persons cannot submit the issues of co-investigating judge impartiality in their appeal. The charged person accused that the CIJs are not impartial. Thus, any extension decision on provisional detention is illegal. Or in the name of the prosecution, we submit that this allegation is improper. The principal criteria for making an appeal against extension order on provisional detention are whether the conditions specified in Rule 63.3 are still being satisfied. In addition, the internal rules allow the charged person to appeal any lacking of impartiality of any chamber of the ECCC by request for disqualification as set out in Rule 34. It is submitted that arguments in the appeal of the defense lawyers in respect of lacking alleged impartiality or bias shall not be considered by the pre-trial chamber, as the issue is beyond the scope of the appeal against extension order for provisional detention. If the defense lawyers are confident that they have satisfactory legal ground for making a disqualification request against any of the ECCC judge, the charged person shall make such request for disqualification in compliance with Rule 34 of the internal rules. In any case, the arguments that the co-investigating judges are not impartial are untenable. It is necessary for the defense lawyers not to base entirely on previous decisions of the co-investigating judges on the translation issue of documentary evidence in making their submission that the extension order for provisional detention is not impartial. It should be recalled that the co-investigating judges fulfill their duties independently and impartially, while other parties may or may not play an active role during their investigation. The extension order for provisional detention was based on legal and factual arguments as stipulated in Rule 63.3. It is unreasonable to argue that the extension order for provisional detention issued by the co-investigating judges is as a result of a separate decision on the translation right. The decision on the translation of documentary evidence is irrelevant to the legality of provisional detention. Therefore, the arguments made by the co-lawyers of the charged person in respect to the CIJ's impartiality are untenable. Your Honor, I would like my international colleagues to continue our submission.
The President, the co-prosecutor, international co-prosecutor, you now take the floor.
Mr. Dismail, in view of the time, I'd like to be sure that I will not be cut short in the midst of my presentation. Shall I develop the arguments now? I should take about 20 minutes. Or do you think the lunch break will cut into my presentation?
the President. As requested by the co-prosecutor, we will adjourn for our lunch break, and the chamber will resume at 1:30 this afternoon. The graphic, all rise.